City now.
All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our next case is Cutter versus Vojnovic, and we will hear from the appellant.
Good morning, Your Honors, and may it please the Court. My name is Alex Roy, and with me is Preston Odom from the law firm James McElroy and Deal. And with us as well is Mr. Cutter and his wife Alexa Cutter and their family friend. Thank you for having us here this morning. Certainly better weather today than last week when we were supposed to be here to talk about America's favorite culinary pastime, the hot dog. This case involves whether the trial court committed reversible error in granting summary judgment and finding that there was no material disputed fact of whether Mr. Cutter and Mr. Greg Vojnovic created an oral partnership to purchase with the goal of purchasing 3 hot dog restaurants in Ohio. We believe that the trial court did so commit reversible error. This began in August, approximately August 2019, when Mr. Cutter, who throughout his recent career, he has engaged in private equity and he finds deals and he purchases companies and holds them. And in August 2019, he was alerted to a deal in Ohio for these 3 hot dog restaurants. Mr. Cutter did not have experience in the restaurant industry, and he reached out to his old friend, Mr. Greg Vojnovic, and said, "What do you think about this?" On August 5th, I believe, he gets a confidential memorandum from the seller that has the terms of the deal, and Mr. Cutter, 4 days later, sends the confidential memorandum to Mr. Vojnovic for them to review. They do review that, and together they agree to form a partnership to go after this business for seeking a profit to purchase these hot dog restaurants. An LOI is submitted in October 15th, I believe, 2019. At that time, Mr. Cutter sends an email to the seller's broker and says, introduces Mr. Greg Vojnovic and said, "This is my business partner on this, Greg." They sign the LOI. Mr. Cutter signs the LOI. The sellers sign the LOI. And from that point forward, the two of them, Mr. Cutter and Mr. Vojnovic, they act like partners. They spend the next 15 months trying to close on this venture. They reach out to, they hold themselves out as partners to the seller. They meet with the seller. They fly up there together. They engage in due diligence together. Mr. Cutter pays for that trip up there. Originally, the deal was for $12.4 million. That was the original LOI. That comprised a lot of seller-financed money, but the seller did not want to finance it. They wanted to be done and wanted their money up front. So they changed the deal into it was more cash at closing. And so we're trying to come up with how do we do this? And Mr. Vojnovic suggested a sale leaseback. Mr. Cutter was not familiar with that, but he liked the idea. And they together went out and did that. And there's a great email where Mr. Vojnovic, it's in the record, where Mr. Vojnovic says to Mr. Cutter, "Are you okay with how I'm handling the real estate?" Why would he ask that if they weren't in this together? If what I was doing, Mr. Vojnovic was doing, did not affect Mr. Cutter. They were in it together. And he does. He likes it. And they engaged Essential Properties, who is going to buy the real estate at the closing table, essentially, and they were going to lease it back from them. Then in March of the following year, COVID hit, and that created some disturbances in the lending environment and slowed things down. But the two continued to look at this together, again, holding themselves out to banks, to third parties, to brokers, and to sellers, that they had a relationship as partners. Mr. Vojnovic testified in his deposition that well, let me back up. The duties of the partners were also discussed. Mr. Cutter was going to be the money guy, the financing guy, help get it to closing. He was going to provide the $500,000 in equity that was required to purchase the property. Mr. Vojnovic, on the other hand, he did the due diligence to see, was this a legit operation? At one point, he thought it was too good to be true because the value of it was there. And then post-closing, he was going to be the operator of the business. They were still going to hire a manager. Mr. Vojnovic lives in Atlanta. He wasn't planning on moving. So they discussed pre-closing duties and post-closing duties. Mr. Cutter was also post-closing going to look for other restaurants, other acquisitions the partnership could make. And then, so they're constantly looking at the different ways to finance this to bring the seller what they wanted at closing. That was a term, it's important, that financing term was something the parties were willing to work out. Mr. Vojnovic specifically says that was something we would figure out later in his testimony that we cited. And in October of 2020, a problem arises. They've agreed at this point to SBA funding. They're submitting, both Mr. Cutter and Mr. Vojnovic are submitting to Home Trust Bank, which is the SBA lender, submitting their tax returns, submitting their documents. They're telling Home Trust, Mr. Cutter is going to provide the $500,000 equity. Here's his bank accounts, operating as a partnership. But in October of 2020, Home Trust tells Mr. Vojnovic that he needs to, there's some debt associated with a company that he used to own called Island Restaurant Group, about $148,000 that was still due. And that needed to be paid before they could approve or they could submit the loan. Mr. Vojnovic says the loan had already been approved, but they needed that to be paid to submit it. And Mr. Vojnovic says to Mr. Cutter, well, you're supposed to do pre-acquisition costs. You need to pay for this. And this is the first and only dispute between the partners, is who is going to pay the $148,000 that is not disputed related to Mr. Vojnovic's old 10-plus-year-old debt. That is not a partnership, has nothing to do with the partnership. And Mr. Cutter refuses. At one point he says, I'll put it in escrow at the closing table, but Home Trust Bank did not want to do that. And so they start looking for other ideas. November 10th, Mr. Vojnovic emails Mr. Cutter and says, I'm exhausted, but we're done. Everything is together. All material terms. The financing is done. The holding entity, which, by the way, was a hot dog shop holdings entity, an LLC, formed under Georgia law, that they both discussed. And Mr. Vojnovic specifically says, I got approval from Mr. Cutter to do that. They discussed whether it was a North Carolina entity or it was a Georgia entity. At one point, it was going to be Cutter Family Properties. But they discussed it, and they said, yes, I'm okay with it being a Georgia LLC. Why would they do that if they were not in this together? That has all the indicia of a partnership. So he says, we're all done. Everything's agreed. You just got to pay the $148,000. Mr. Cutter, again, says he doesn't want to do that. And on November 12th, he says, I'll develop some other options in line with our original 50-50 agreement. Then very next morning, Mr. Vojnovic sends an email that says, no, and I feel the need to inform you that the contracts are no longer in your name. Meaning they were in his name previously. They did have an agreement, and I'm leaving the partnership. I'm ousting you from the partnership because you're not paying my old debt. And that is the only dispute between these partners the entire time. And then Mr. Vojnovic stole the deal and closed the deal and pocketed the partnership's profits. A partnership under North Carolina law, it's General Statute 59-36, is that two or more persons to carry on, an association of two or more persons to carry on as co-owners of a business for profit. There is no question that these two individuals intended to carry on a business for profit. In the record, there's an email that Mr. Cutter sends to Mr. Vojnovic. He calls it the sources and uses, and it's a spreadsheet. And they go down through the purchase price and the different funding sources, and then how much money they're going to profit at the deal table. And it's 50-50, and it says 50-50 ECGV. And Mr. Vojnovic says, that's what I'm talking about. It's a split of profits. It is not compensation for wages, and that was important in the Potter case, which is the last time I believe that this court, the Supreme Court, has considered an oral partnership or a partnership in general as the Potter versus Homestead case, and said that, one, the fact that an LLC was going to buy it does not matter to a partnership. You can have an LLC holding the land that is owned by some of the partners, and there still be an overarching partnership. That was by this court.
So the business court, in holding that there was no partnership, said that under this court's decision in Johnson v. Gill, to have a partnership, you have to have an agreement on losses or how to divide losses. What's wrong with the business court's reasoning there?
A few things. One is the statute says two or more to carry on a business for profit. It doesn't talk about losses. Second is in the statute, I think it's 59-48, I believe, that says it's the statute dealing with the formation of a partnership. There's nothing in there about there has to be an express agreement as to losses. When we see later in the statute, it says in the absence of an explicit agreement between the partners will split losses in the same ratio they split profits. So our statute supplies that term in a later part of the statute. It's not in the formation. It's not required in the formation. But you're right. Our courts have said that it has to be profits and losses. And I think that goes back to pre-Uniform Partnership Act, that quote. I'm not aware of a thorough review of every case that we've submitted to the court, which is numerous. I'm not aware of a single case that says, like the trial court in this case, that the failure to explicitly do that is fatal to the formation of a partnership. Moreover, I think in this case, there was actual splitting of costs beforehand. And you may say, well, costs are different than losses. Well, if there's no profits, those costs become losses. And there was a splitting of losses. Mr. Cutter paid for legal fees. He paid for due diligence. He paid for their trip to Ohio. Mr. Vojnovic paid for the loan commitment fee of $10,000. And then Mr. Cutter was putting in $500,000 of equity, not a small amount. And then they were going to leave they already planned to leave, I think, $300,000 in the operating account for future the ongoing concern of the business. So in essence, they had an implied agreement as to what to do about the losses. A partnership certainly can be an oral contract. It doesn't even have to be discussed. It can be the acts and declarations of the individuals. So it doesn't make sense, it sort of belies the point to say, well, you also have to have an express discussion about losses. But you don't have to have an express discussion to become partners, but you do on the one term. I don't think that makes any sense. So I think we can look to the acts and declaration of the partners. They're clearly splitting profits. They're clearly splitting cost as the partnership was going towards its goal, its profit goal of purchasing the restaurants. And then they were going to own it 50-50 after that. And the hot dog shop holdings was 100% owned by Mr. Vojnovic, but Mr. Vojnovic also testifies that Mr. Cutter was going to have a 50% equity interest in that. And so clear there's an intention they're going to own this business together and they're going to split the profits. So I don't think it's fatal. I think our statute supplies the term. I think it's the Longley case where it's the two brothers and they're selling off their cars and they say, you know, there is a partnership, and what happens when they don't talk about what to do with the losses. They thought there'd be more money at the end, and the court rightfully uses the statute and supplies that term. It says you split it in the same ratio as the profits. So I believe it doesn't. Also,
So if there was, help me understand, if there was a partnership, then how does that affect the claims? The trial court's reasoning then it would be, that really wouldn't have any effect on whether or not you could bring derivative claims or the tortious interference reasoning, but it would matter, I take it, for your claims about breach of partnership, the fiduciary duty and or sort of traditional breach of agreements through the partnership. Is that the argument?
absolutely. Yeah, absolutely. You have to find the partnership, and these claims derive from it, and the tortious interference is alternative claims.
We would still be reviewing de novo whether or not summary judgment would be appropriate on those claims if there was a partnership.
Correct.
So what evidence do you say creates a genuine issue material fact about, for example, breach of the partnership agreement when, you know, I think what we're going to hear from your friend is the partnership just couldn't agree to carry out an attempt to acquire the business, and nothing prevented him from going and finding another business opportunity to do the same thing because this partnership couldn't do it. What's your response to that?
I mean, I think it's sort of a manufactured reason to say I'm going to have this. My side issue is creates an excuse for me to unilaterally oust you from the partnership. I think that's up for a jury to say whether that was right or wrong. I think it's up for a jury to say that whether there was a partnership, and a jury should determine whether that was okay for Mr. Vojnovic to say, I'm cutting you out. All the contracts are no longer in your name. I'm taking the exact deal that we worked 15 months to do. I'm taking it for myself. I'm taking all the money. And I've just had my brother come in and loan me the money to get to closing, and that's it. And so I think it's up for a jury to say whether that was right or wrong. I think the Cap Care case is as close as a case on factually as can be found on any subject. And that it was an agreement to purchase real estate. I think it was a hotel in, a commercial building in High Point. And the two guys got together and said, we're going to buy this building. And they're going through it. The defendant says, well, I'm going to buy this building in my separate company. Is that okay? And they say yes. And they get all the way there and they get up to the consummation of it. And then the defendant refuses to give any of the profits to the plaintiff. Exact same scenarios here. And in that case, I think it was affirming a jury award that says you can't do that. That's not okay in North Carolina to unilaterally oust someone from the partnership and take all the gains. So I think it's the evidence that Mr. Vojnovic refused to let Mr. Cutter participate in the business going forward. He ousted him without reason. Does that answer your question?
It does.
Okay. So I think clearly there's an intent here to split profits. I've shown the email that we've talked about. I think it's also important that splitting of profits is not compensation and I cited the Potter versus Homestead preservation case. The second required to form a partnership is co-ownership of the property. Here it's the business opportunity and then the actual business. I think there's clearly an intention to do this together, clearly an intention to co-own this property. I don't even think that's contested. I think that is rife through the records that that's what they were going to do and then split the money. It's on record site page 835 where Mr. Vojnovic says holdings was going to be 100% Greg Vojnovic, but Ernie Cutter owns a 50% interest in that. So clearly an ownership in the business. Also, I talked about the Cap Care case. I think the Reason case also talks about agency. I think the Reason case is also an excellent case that's very similar. It's about handling real estate just like this, and talks about the agency concept between partners, and that you have to each partner is an agent of the other partner. I think that is clear here, as evidenced by emails such as, "Are you okay with how I'm handling the real estate? Feel free to talk. This is my partner, Ernie Cutter. Feel free to talk about him, about anything with him. Ernie, feel free to reach out directly." They're giving each other agency over one another's affairs. And that, to me, is very clear evidence of a partnership. Courts have also held that splitting profits is prima facie evidence of a partnership. Here we've gone through, I think, that the clear intention was to make a profit, and they would have done that together had Mr. Vojnovic not ousted him. And so I think that is prima facie evidence in this case of a partnership. Courts also, and if it's not too late, I meant to say I'd like to reserve 5 minutes of rebuttal if it's not too late, and I apologize. Courts have also analyzed this to meeting the minds and formation of a contract. And here we believe that to have certainly occurred. The Grubb case, which is an unpublished table site from the Court of Appeals, goes through that directly. And it goes through and says these partners, there's two guys who were going to buy this real estate, and they met at a steakhouse. And the court found in the Grubb case that that was sufficient enough, there was sufficient enough detail about purchasing this entity at a 50-50 basis at the steakhouse. Nothing more, it was high level. And that's where the meeting of the minds occurred. That's where the partnership was formed. And then over the next few months they carried on as partners. I know my friend will cite the Miller versus Rose case. I know that was important to Judge Bledsoe. I feel like that case is very different. This is the Myrtle Beach condo case. In that case, as we cited in our brief, I believe it's a very, very different factually. There, the putative partners, there was a conditioned precedent to formation of a partnership. It's if we get the financing, then we will become partners. And they cite to a letter that uses those words, if, then. And before we consummate our deal, we must do these things. And so in that case, those terms, that conditioned precedent was financing. In this case, it's not. Mr. Vojnovic and Mr. Cutter are both okay with figuring that out later. Mr. Cutter specifically says that on record site 824, he specifically says we would figure out that later, talking about the financing. So I think that case is not similar. There's not a conditioned precedent in this. Financing was not a material term between the partners here. Here there was also an agreement before. So there, in that case, they say it's an essential term. It's not an essential term here, but also there was an agreement on financing. The November 10th email from Mr. Vojnovic to Mr. Cutter specifically says, everything's in place. The only thing you need to do is fund my $148,000. The loan terms are done. The seller's terms are done. Every facet is done except for paying this one thing, and that you need to pay it. And so here there is an agreement as to all the partnership terms, all the financing terms at that point in time. But before that, they said that's something we were going to work out later. Also, I think there was some dispute at the trial court whether finding an operator once post-closing, was that a material term, and that hadn't been agreed on. Mr. Vojnovic says on record site, page 831, that was something they were going to figure out later. Again, the partners agreed to figure out these terms later. It was not a material term to this partnership. In the Northington case...
Is it possible for someone to be a partner in two different enterprises that are, or a member, whatever it might be, with two different business entities, both pursuing this, trying to get the same deal done, and assuming no breach of fiduciary duties and helping one or the other, the fact that one does it before the other,
I mean, two
Doesn't
competitors, essentially?
Right, two competitors trying to buy this, and you happen to have a partnership stake in both of the bidders. The fact that one succeeds before the other wouldn't, by itself, give rise to some breach of contract claims in the partnership of the other one.
Yeah, I think it'd be a breach
So
of
what is
fiduciary
it
duty.
here that is, you refer to as sort of, your client was ousted from the partnership, but your friend might argue, well, there was just, I was exploring other business opportunities at the same time, and that's the deal that ultimately got done. What's your response to that?
But he wasn't. I mean, there's no evidence whatsoever that Mr. Vojnovic was unilaterally also, as a competitor to him and Mr. Cutter, he was competing against their partnership in his own right. There's no evidence he was doing anything on his own. Every single email is we, I should. I mean, we, us, our group. I mean, it's all these things. It's us together, and so there's no evidence that he was pursuing it individually. And so he learns of the opportunity under the partnership. He gets the confidential terms, and it is a non-binding. I know my friend is gonna talk about how it was a non-binding LOI, but the conveyance of information from the seller to the purchasers, that was under a confidentiality agreement. And so Mr. Cutter was able to share it with Mr. Vojnovic pursuant to that confidentiality agreement. He gets access to this information. He only learns about the deal through his work in the partnership. And so I think it would be certainly a breach of his fiduciary duty to then go compete against the partnership in his own right. He would not be allowed to do that. He'd be disobeying his duties of loyalty to the partnership to do that. Maybe, I guess it'd be a different set of facts if that was explicitly discussed, but there's no evidence of that case here. It was them doing it together. The sellers understood that. The bank understood them that they were doing that. And so I think when you hold yourself out as we in a partnership and us doing this together, you should be bound by that. And you shouldn't be able at the last minute say, well, I've got a whole bunch of bad debt. I want you to pay. And if you don't, now that excuses me from performance. I mean, that would allow, the court holds that, and it's allowing a partner's bad acts to benefit them. And I don't think that should be the public policy of North Carolina, to let somebody's bad acts here, which is not in question, give them an out. And if that, I believe I've reserved my time.
Thank you, counsel.
May it please the court, my name is Tom Hooper. I am the attorney for the defendants appellees in this case, Greg Vojnovic and Hot Dog Shop Holdings, LLC. We've chronicled in our brief the factual situation that led us to where we are today, but briefly, I think it's important in light of what Mr. Heroy has already said to make the point that when these two men started looking at this opportunity, Mr. Vojnovic was not going to guarantee a multi-million-dollar loan. Mr. Cutter had promised him, and this is undisputed, that Mr. Cutter would close this deal, would acquire the funds for this deal, and would set up the structure of this deal. And by the time we reach the end of their year of trying to get this deal done, Mr. Cutter has not closed this deal, Mr. Cutter has not structured this deal, and Mr. Cutter has not obtained the funding for this deal. In fact, Mr. Vojnovic is the one who's on the hook entirely for a $4.25 million loan. Mr. Vojnovic is the one who paid the $10,000 loan commitment fee. Mr. Vojnovic is the one who led the two partners, or not partners, but alleged partners, through the application process for the HUD loan. Mr. Vojnovic is the one who went out and got arranged for the sale leaseback transaction, which made possible the acquisition of the real property here. So that's where we are at the time that Mr. Vojnovic is deserted by Mr. Cutter and has to do this deal by himself. Now, what I found interesting, I found many things interesting about Mr. Heroy's argument, but the first one is that he sort of glosses over the fact the statutory definition for a partnership requires at a minimum an association of two or more persons to carry on as co-owners a business for profit. There, in fact, was no business for profit during this relationship. The goal was to get to a business for profit, but there wasn't one during the entire dealings of Mr. Cutter and Mr. Vojnovic. They never co-owned that for-profit business. And why did they not co-own the for-profit business? Because the financing deal did not work out. They, according to Mr. Cutter and Mr. Heroy, never had a deal on what to do about the what we refer to as the IRG loans in our brief, the old SBA debt. And notwithstanding Mr. Heroy's continuous attempts to downplay that and say it's not material and that it has nothing to do with the business, they couldn't buy the business without having that debt paid off. I don't know how it gets much more essential or material to this transaction than that. Without that, you don't get to go forward, and there's no dispute as to that issue. These two men spent a lot of time trying to line up the financing and could not. The brief that Mr. Cutter has submitted to this court refers to the ability to pay off that old SBA debt as a, quote, pivotal detail. And so, again, I don't understand how he can now say it doesn't have anything to do with the business, and how he can also say, oh, we were all okay with figuring it out later. Well, you can't figure it out later because you can't buy the business until you figure it out now. So there's no putting it off later. There's an example that they cite, I think it's the Grubb case, where they say, oh, we'll figure out later what sort of organization we're gonna take, whether we're gonna be an LLC or a corporation. But those people in that case were already in business. They were already owning and operating a restaurant business. So they could afford to wait. We couldn't afford to wait here because we couldn't get to the for-profit business without this financing. There is a thing in the brief that in Mr. Cutter's brief that I feel needs to be addressed, even though Mr. Heroy did not raise it now. In passing almost, they claim that there's now an issue of fact as to whether they had an agreement on financing. That is, and specifically on how the SBA debt would be paid. That's the first time that argument's ever been made in this case. It wasn't made below, wasn't made in their principal brief. It's made for the first time on reply. And it's entirely inconsistent with everything that they've argued up to this point, which is there was no agreement on how to pay off that old SBA debt.
Do you think there was, in your view, an agreement on how to share the profits in this case?
If they got to the point where they co-owned a business, I think they were going to split the profits 50-50.
So what if we think that the Johnson case means that we can infer an understanding if you agree to share profits 50-50 in the absence of some express agreement of how you're going to split losses? If we can say we can infer that the partnership intended to split both profits and losses, that you would assume whatever the split of profits is would also be the split of losses. And if we said that here, then that would mean that you could get to the formation of a partnership. Well, I mean, I assume your answer is that's not what Johnson says, but imagine we were trying to read it that way. What's your take on that?
I think there are two things with that. The first thing is, to go back to the first point I made, is that there's no co-owned business yet. So there's no co-owned for-profit business yet. So to get to that question, we have to first jump that hurdle. But assuming that we do, then I think that so if you read Johnson, it says that to make a partnership, two or more persons should combine on and on and on, and under an agreement to share the profits and losses in equal or specified proportions. To make a partnership, they have to do that. And so that's and I think that was a deliberately chosen word. So I don't think it's appropriate to infer that there was an understanding to split losses. Also, in this case, when you look at the record in this case and you look at how little Mr. Cutter actually was involved financially, and I'll take just one example. When it came there's been an argument made that, oh, he was going to put in $500,000 in equity at the closing. But as we've shown in our brief, the only reason he was going to put in $500,000 was because he was going to get out more than $500,000 at closing. So there was not going to be any risk associated, or for him, there was not going to be any risk with that.
Can I just understand the first point you make about there's no business yet, so there's no partnership?
Right.
Then, in your view, under a common law unwritten partnership, the fact that parties might be working together to explore what it takes to set up a business and expending their resources and collaborating together and sharing confidential information together, that none of that creates a partnership, and they wouldn't, if this deal had worked out the way it was contemplated, they wouldn't have a partnership until they actually signed all the closing documents and owned a business that they were operating? Is that your
I think that the concern that I would have is if that were the case. And if this court were to decide that we are going to say when two people are trying to buy a business, as what was happening here, we are going to impose on them all of the duties that we would impose on a partnership. Suddenly, now they owe fiduciary duties to each other. Now one of them is completely liable for the acts of the other. They can act and bind the other person.
Well, I guess where I'm going with this is what's the legal authority for that proposition that you can only find through the acts and the what parties are doing with each other, that you can only find that there's a partnership once there's an ongoing business concern that they're operating?
I think it's the statute. I think it is the statute that says, and it is 59-36A, that says an association of two or more persons to carry on as co-owners a business for profit.
Right, but to carry on a business, you do have to do the formation part of it, right? Like, it's not like the business is going to spontaneously exist. Like, there's just all sorts of ways in which people come together and figure out how they're going to start operating a business. And it just seems to me that language doesn't mean that it's only when the doors are open and income's coming in that we then have a partnership.
I would submit that again. Well, I would respectfully disagree, because I think that before we again impose all these duties and obligations and liabilities and everything on people, I think that they need to be in the business already, in a business for profit. Otherwise, I mean, if two people outside right now are talking about just buying a business, do they suddenly become partners? I mean, I'm not sure at what point in time you would say that Mr. Vojnovic and Mr. Cutter even became partners.
But isn't the protection against that you would still need a meeting of the minds on the material terms of the partnership, even if because there's no express partnership agreement. And so that would be the protection of the things you're saying, is you would not only have to show that you were doing that to form the business, but that there had been a meeting of the minds about what this partnership agreement would be. And at that point, it seems to me it is reasonable to impose those partnership duties on the people that entered into that agreement.
Well, and here there's not that meeting of the minds, because there's not the meeting of the minds on the financing. There's not the meeting of the minds on the terms of what the business is going to be like when it's being run. I mean, our brief cites to the fact that when Mr. Cutter was asked, what are the details, what are the key terms of your business, and it was 50-50, the quote was 50-50 on the economics, splitting the economics. And then Mr. Vojnovic is going to operate the business, and I think the language was, and so forth. At
what point, in your view, would they have been carrying on a business?
I think after they closed.
So the purchase means you're then carrying on a business.
I think so. But let me also say this.
Let's back up a little bit. Let's say they both signed on to the financing document, indicating that both were going to pursue closing the deal. It's before it actually has closed, but they're both personal liable, guaranteed the loan, whatever, surely you can have a partnership before it actually closes.
I don't know that if you have to co-own a business, you don't co-own the business yet. You don't have title to the business until after it closes. But let me also say this: Judge Bledsoe found that this, because we're assuming that that's where this was headed, is that it was going to be a partnership. But Judge Bledsoe actually noted that the ultimate goal was to form this and own this business as a limited liability company. So now we have a situation where there's a clearly expressed intent to own this business as an LLC, not even as a partnership. And in fact, the Uniform Partnership Act specifically has a provision that specifically says that if you form an association under another statute, it's not a partnership under this article. It's inconsistent to argue that these two men were partners or were going to be partners when all along the plan was to be a limited liability company. And of course,
See, I think that to me is something that cut the other way, because isn't the idea that you form the partnership and the business you're carrying on is the business of acquiring this other business that you intend to profit from, at which point you'll form the LLC. But until that happens, the partnership is carrying on a business, which is there's a profitable entity that you want to acquire as a partnership in order to make more money.
but while they're doing this, while they're pursuing that opportunity, they're not in any kind of business that conceivably could generate a profit. At that time, that's not a profit generating business. The profit generating business is the restaurants. And it may not generate a profit. I mean, but that would be the goal, would be if the restaurants generate the profit.
But doesn't that, I mean, maybe this is a little hyperbolic, but that, you could take it to the extreme. That would say that, private equity firms are not running a business. All they're doing is taking money and finding places to invest it in order to make more money. And so, during that time before they've acquired the business, they're still carrying on a business, which is they're using capital to invest somewhere and make even more money. And it just seems to me that you could form a partnership to do that, and that would be carrying on some business, which is looking to acquire some other business.
Perhaps but if that is the purpose of that business, as opposed to the purpose of this venture, which was to just own and operate the hot dog restaurants, then that's I think the distinction is that while they're doing this, there's no way they're going to make a profit. And again, I think it's different than the private equity firms in that way.
Is there a difference between an association for profit and carrying on a business?
I think that you could, I had not thought about that, Your Honor. I think, though, that the way the statute describes it is you carry on a for-profit business or a business for profit. I don't know that I'm answering your question. But in this case, what they're doing, even if you were to construe it as a business, it is not a business that would be organized for the purpose of making a profit. But I want to address the LLC implications here, and the MAS Associates opinion from the Court of Appeals of Maryland actually addresses this well. I think in that case, which we cite throughout our briefs, it says, the court says, when the parties are actively engaged in the process of negotiating to become members of an LLC, evidence of equal control and joint decision-making authority is not evidence of the parties' intent to form a partnership, which goes back to Mr. Heroy's points about, well, they're out there and they're talking to everybody and they're acting like they're agents for one another and that they have some decision-making ability. But again, the concern that I have is if the court decides that this activity constitutes a partnership, then people are going to be subjected to duties which I don't believe they would anticipate that they'd be subjected to if they're looking to acquire a business, and the way that they're looking to acquire the business is through a limited liability company, where very specifically they don't owe fiduciary duties to each other, and they're not each other's agents, and they're not liable for what the other one does. And there's evidence in this record that Mr. Vojnovic did not want to be in a situation where he was going to be liable for everything that Mr. Cutter did.
Excuse me, can you remind me, I don't want to go back through the record while I'm sitting here, who are the members of the LLC?
At present, the member of the LLC is Mr. Vojnovic.
Was Mr. Cutter ever a member of that LLC?
No, he was not.
Thank you.
And the LLC was formed during the course of this effort to acquire the business. And then we have, the other factor in this that Mr. Roy didn't really discuss is that if we're looking at this and you want to think, well, this looks like a partnership, well, we have a very curious thing that again, Mr. Vojnovic is liable for 100% of an obligation owed by the ultimate business, the restaurant business, and Mr. Cutter isn't on the hook for any of it, which is completely inconsistent with the Partnership Act, which says in 59-45A that general partners are jointly and severally liable for the acts and obligations of the partnership. And when we get to the point where the loan is made, it's made to the LLC and not to these individuals. It's made to the LLC, and that's the point or the goal all along. So Mr. Cutter's never going to be liable for that, which is certainly inconsistent with an intention to form a general partnership. And Judge Bledsoe, I think, accurately found that as well.
So getting back to my question about Johnson, what do you think there are circumstances where you could infer the loss agreement from the profit agreement, or do you just think Johnson would prohibit any inferential agreement? It has to be expressed. The and profits and losses means you can't just assume that the default is if we're splitting profits 50-50, we must be splitting losses that way also.
I think so. I'm struggling to come up with an example of that, and I think part of the problem is I haven't seen a case that says that in North Carolina, that says that, okay, if they just agree to split the profits, that's good enough.
I'm just wondering if Johnson says, if we say that is precedent we need to follow, and it says you have to have an agreement, it didn't say you have to have an express agreement, profits and losses. So I'm just wondering if we could try to interpret it to mean, so you have to have strong enough evidence, though, that you can infer the losses. And I mean, perhaps here you didn't mention it, but maybe the best argument is, in the record, there seems to be there was an acknowledgement that there wasn't an agreement there, which would potentially undercut the argument there was a 50-50 split.
Well, I mean, there is an acknowledgement in the record that there was no understanding to that. I mean, there's language that is as clear, I think, as could be.
Right, who would incur the losses?
And
agreeing for that, no.
Well, the question, yes, that was the first question, and then the second question was there was no understanding about that, and the answer was no.
I'm just wondering if could a reasonable person give that answer, because you're saying, well, because we know the default is if you're going to split profits 50-50, you're of course splitting the losses 50-50. Would be you would need the agreement, maybe even the express one, to say we're going to split profits 50-50, but losses are something different. Although, in this case, maybe an example where you might have an agreement like that, particularly where one of the partners is putting in all the capital. But I'm just wondering, is the default 50-50 both ways? And that's
I don't. Well, you say it's the default that both ways. I don't know how you can testify that there was no understanding about how the losses, what would happen to the losses, and then say, but in the back of my mind, I secretly thought that, of course, we would split the losses. They were going to own and operate this thing as a limited liability company, not as a general partnership.
I'm sorry. Before you go on, what's wrong with the argument? And maybe I'm misstating it. That 59-48(1) supplies that default rule on the splitting of losses
Yes, so,
or the division of losses.
right. I think that statute, so in the case that they've cited, Longley, which talks about that, there was already a partnership. There was no dispute that there was a partnership. It's an ongoing business. There was a problem in that the dissolution agreement in that case did not specify how the losses would be handled. And so the Court of Appeals said, well, you split them based on that statute. But that, I think, is that statute applies after we cross a threshold determination as to whether there was in fact a partnership or not.
But I am struggling to understand the answer, because if your contention is that there can only be a partnership if there's an agreement on profit and losses, then at some other subsequent point after the business is underway, there would have to have already been an agreement on profit and losses, and there would never be a circumstance where the rule in that statute would have to apply.
Well, I think that the statute would apply if, let's say we agree that we're going to share the losses, but we don't agree, like, well, what does that mean? Does that mean you get 50 and I get 50? Or I think this goes back to something that Justice Dietz was raising. Well, if I contribute more than you do, then make a capital contribution that's bigger than your capital contribution, then what do we do? But we could have a sort of a threshold decision of, all right, well, we are going to share the losses. And then we get to this point, and
Isn't that answer inconsistent with what Johnson says? Because Johnson says that to make a partnership, you have to have an agreement to share profits and losses in equal or specified portions. So doesn't that rule out the scenario that you just described?
So I think that you could have, that could be a situation where there's a question of, well, if you have to have a specific thing under Johnson, then how do you reconcile it with this statute? I would point out that Mr. Roy said he didn't know whether Johnson was before or after the act was enacted, but Johnson was decided after the Uniform Partnership Act was enacted. So that is the law even after that. And
so are you saying we'd have to overrule Johnson?
I think that you could continue to hold that there has to be some agreement as to losses before a partnership is formed. If you want to get to a point where you agree with Mr. Roy's position, maybe you do have to overrule it. It was consistently followed before the Uniform Partnership Act. It's been applied after the Uniform Partnership Act. It's cited not just in Johnson, but other cases, including Miller versus Rose. So as it stands right now, that is the law of the state of North Carolina.
But you do see the problem that Justice Earls was highlighting, which is if Johnson says you've got to actually agree on not just a general agreement or in principle, yeah, we'll divide losses, but you got to say in equal or specified amounts, then it does seem to render 59-48(1) superfluous, doesn't it? I mean, given the way you interpret the statute and your interpretation of the statute, which is it wouldn't apply until after you already have a partnership going.
Right. I imagine there could be situations where other partners come into a partnership and you don't have an agreement. There could be a situation where you have a partnership agreement that supersedes an earlier partnership agreement and doesn't address this question, and then that statute could come into play. So there possibly could be other scenarios where the statute would still stand for some later decision about how we're going to split losses. I want to make the point too, and Judge Bledsoe found this persuasive as well, is that to go back to this notion of whether these two are partners or not, there are a series of indicia that are simply absent here. Maybe not one single one of these would defeat a partnership, but collectively you look at it, and to me it is evidence that there was no partnership. There's no written partnership agreement ever. There's no co-owned real property. There's no co-owned personal property. There's no joint bank account. There are no partnership tax returns. They didn't register a partnership name. They didn't contribute capital to a partnership. They did not share profits. There weren't any profits to share. They didn't share losses. There weren't any losses to share. They weren't doing the things that you would expect of a partnership. And we've cited in our brief La Familia, which lists those various indicia, and also Wilder versus Hobson, a Court of Appeals decision, references those various factors. I'd like to turn briefly to this issue of the derivative claims. I'm running very, very short on time. But of course, if there's no partnership, there can be no derivative claims by one general partner on behalf of the general partnership. And in this case, as we point out in our brief, the derivative claim, there's been no case in the state of North Carolina that's ever recognized a right of a general partner to sue another general partner derivatively on behalf of a partnership. There's no right under the Uniform Partnership Act, in contrast to the right that the General Assembly has specifically granted to shareholders and limited liability company members. The General Assembly knew how to create a derivative claim. If they wanted to do one for general partners, they would have put one in. Mr. Roy did not talk at all about the tortious interference claims, and perhaps that's because there's just a complete lack of admissible evidence to support a tortious interference claim in this case. That claim was pleaded in the alternative to the partnership claims. There's no sufficient evidence of causation, of but-for causation here. All the evidence that he attempts to rely on to support his claim violates Rule 56. It's speculative, it's conclusory, it's nonspecific, and in some cases it relies on hearsay. Mr. Cutter cannot testify whether the business would be sold to him without Mr. Vojnovic. He can't testify as to whether he would get a loan to close the deal. He couldn't testify as to who the lenders would be. He couldn't identify who his investor friends would be that would, he claims, support him, where his own money would come from if he were to try and use it, et cetera, et cetera, et cetera. And certainly doesn't identify with the required specificity any of the details for how he would have done the deal without Mr. Vojnovic. So with that, we would respectfully request that this court affirm Judge Bledsoe's ruling granting the motion for judgment on the pleadings, affirm Judge Bledsoe's ruling on the motion to strike the affidavit of Mr. Cutter, and affirm the summary judgment order.
Thank you, counsel. Rebuttal.
Thank you, Your Honors. Going at some of the questions that were asked of my friend about the makeup of the LLC versus the partnership, specifically Justice Berenger, you asked who owned this. And Mr. Vojnovic answered that for us on record site 835. He says, the question is, and you and Mr. Cutter were owning that holding company 50-50. Answer, yes. And the question, okay, splitting the profits 50-50. That was the intent. Question, and did you respond in the subsequent email the next day that you're actually going to be 100% owner of the holding company, but Ernie would have a 50% financial interest? Is that correct? Yes. So that, I think, supports what we're arguing here today, is that LLC is equivalent to a single purpose LLC. That is, the target is buying these 3 hot dog shops, but there's an overarching entity, which is the partnership that Mr. Cutter has a 50% equity interest, a 50% financial interest in.
Can I ask you about what seems to me to be your friend's strongest argument, which is that even if there's this default in the general statutes, essentially, that says profits and losses are going to be 50-50 unless you say something else. And then we confirmed that in the Johnson case by saying that is the case, but let's even assume that Johnson holds open that you can infer the losses from the profits. Even given all that, the argument is here, your client said under oath, we did not have an agreement on losses. and their client says we did not have an agreement on losses. And so, I'm sort of paraphrasing the argument, but it would be the law, an implicit, an implication that the law might otherwise impose cannot override both parties' affirmative statements that we didn't have an agreement on this. And if an agreement on that is required for the partnership wasn't formed. So what's your response to that argument?
I think it's a great question. I think that the acts and declarations, I don't think you have to overturn Johnson. I think that the Supreme Court, particularly in Potter, has answered that and said the acts and declarations of the party, the intentions of the parties can make those implied terms. And so because there was not an express understanding as to the losses, we can imply it. And also the legislature has supplied that term because so often partners don't talk about that. I think it's I can't remember if it's the Maryland or Tennessee case that says, no, sorry, it's the Grubb case. It's the Grubb case from the Court of Appeals that says so often partners, when they're starting a business, they focus on the upside. They talk about the profits, but they don't talk about the negative. People don't go into business to lose money. So you're focusing on the positive. And so that's why our statute, as Justice Earls was saying, that's inconsistent to say you have to have a meeting of the minds, but yet then why do we have this term if you can't ever get to a meeting of the minds without the term? And so I think it absolutely is implied here. I think their acts and declarations do that. I think the statute supplies it. I think in the Longley case, very specific. There's no discussion about losses. And in fact, most of the cases, there's no discussion of losses. In the Potter case, no discussion of losses. The Reddington cases, no discussion of losses. Northington, Longley, Capcare, and Grubb, in all of those cases, no discussion of losses. Longley, in particular, there's no discussion of it and says, well, we have a statute for that. We supply the term. And in this case, it's very clear you're going to split the economics of the case 50-50. You get the burdens as when you get the benefit. And we have that in writing that you're splitting the benefit. And so if there was a negative, you're going to have to split that. That's what the court would ultimately force them to do, I think. Yes. Again, talking about so in support of that you don't have to overturn Johnson, I think the Capcare case, again, a partnership may be formed by an oral agreement. Even without proof of an express agreement to form a partnership, a voluntary association of partners may be shown by their conduct. A finding that a partnership exists may be based upon the rational consideration of the acts and declarations of the parties, warranting the inference that the parties understood they were partners and acting as such. That's what happened here. I do believe that the trial court got this wrong, and we'd ask that you overturn the trial court. And in terms of Mr. Cutter, well, my time's out, so let me stop there. Thank you all very much for hearing this case today.
Thank you, counsel. Mr. Clark.